Hello there. I decided to do this quick video with the new year coming. There are new laws that are coming on board that I thought are very, very important. As I mentioned before in my previous videos, this coming year has brought on a slew of employment laws that affect pretty much every aspect of being a California employer. Probably the most amount of laws since 2019. I picked these five because I feel like these have a broader implication, and really also because of space. I will be doing more and more videos to cover all the upcoming laws, but I wanted to start with these. These are the five new employment laws that every California employer should be aware of. The agenda is relatively simple. There are five areas of the law: AB 1041, AB 1941, which is the bereavement leave, the SB 162, which is the posting pay ranges and reporting requirements, AB 2118, which is what I call the Puff Pass law, minimum wage for 2023, again, a general one, not covering the specific cities. And I will probably cover some of the COVID stuff as well. So let's get into it. So AB 1041 adds a new section to the Medical Leave Act, which is for qualified employees who worked for a year, 250 hours, can take up to 12 weeks to take care of a sick person as a family member, which is child, spouse, domestic partner, grandchildren, things like that. Well, now they've added a new category called a designated person. Well, what the heck does that mean? Basically, it's any individual related by blood. So it could be a cousin, or the one that's a little bit makes this kind of blows this wide open is whose association with the employee is the equivalent of a family relationship. Well, that can be a family friend. That can be a dear old neighbor. It can pretty much be anyone. Now, this does apply to all California employers that have 5 or more employees. Yes, you can designate and limit the employee to pick a person annually. So there's that. So they can't just willy-nilly tell you. But beyond that, employers need to be aware and be careful and make sure they have this in their handbooks, because if they think this sounds, if they're not aware of this law, they can get themselves in trouble quite a bit. So keep that in mind. The second law that affects a lot of employers is a new leave. It's called the bereavement leave, which by this new law, employees can request up to 5 days of leave upon the death of a qualifying family member. This is still within the traditional the language, which is child, spouse, grandchild, sibling, domestic partner, in-law. So the designated person, keep that different. This is just for family. Now, having said that, you cannot require an employee to take up to 5 days consecutively. They can take it up to 3 months. They have 3 months to finish the 5 days. If they also have accrued PTO and they have sick leave, you must allow them to use that. And so this applies no matter what. This becomes a little bit problematic where if you must treat this information as confidential, you can't discipline, discriminate, retaliate because somebody's taken a leave. And the part that's even more expensive is this can apply to employees that have only worked 30 days. So this applies to new employees as well. And so if they work for 30 days, they can get this leave. And so employers need to keep that in mind. For a new employee, obviously more likely than not, it'll be an unpaid leave. But again, now if you are offering a leave in your employer place, but if it's less, you must adhere to this and add the 5 days. If you offer 3 days paid, great, and then the additional 2 days would be unpaid. So keep that in mind. And this is the part that this one's a little bit concerning, only in the sense that this is SB 1162, which is really about posting ranges for employers that have 15 more employees. Going forward, if you are going to post a job requirement, you must post a pay range, which is the salary or the hourly rate that you employer is expecting to pay that person. Where it gets a little wonky is employees that are currently working for you can request that same pay range, and you must provide that information. So, and if you don't comply with that disclosure, you potentially could result in penalties of up to $10,000 per violation. Now, employers with 100 or more employees have longer things that they have to do for the EEOE, and they have to do race, gender, a whole breakdown. And I do think California is slowly moving to of transparency, where there's no confusion. And so I think this is the future. This is why I thought it was important to talk about it. Now, the second one, this is the one I call the puff puff pass rule. This doesn't take into effect till 2024, but this prohibits employers now from discriminating against a person because of cannabis use while off the job. So what does that mean? So employers may take action against someone who fails a pre-employment drug test or any other employer-required drug test, but one that does not screen for non-psychoactive cannabis metabolites. What the heck does that mean? It basically means that you need to be starting a drug test that shows that they're not impaired. I mean, if they have cannabis or something in their system, but they're not impaired, and then they used it a few days ago, you can no longer sit there and take action or discriminate against them. Now, this law luckily doesn't apply to employees in the building or construction industries or any positions requiring a federal background investigation or clearance, and doesn't preempt state or federal laws that requires employees to be tested for controlled substances, normally state government positions. But this is the reality, the new reality that employers need to be aware of. And I think with these new laws, which means is there potential for new liabilities. And so you definitely need to talk to your employment lawyer and also update your employment practice liability insurance. Finally, as I'll say, the worst news for last. One of the things that a lot of employers were expecting was a range from 2012 to 2000. There was a 5-year range where they were supposed to, from starting in 2016 to all the way to next year, it was supposed to be that every year there'd be an incremental increase. Well, what the law also had that a lot of employers weren't aware of is that they also said that if the rate of inflation exceeds 7%, the minimum wage for all employers must be set as the same amount, which means now essentially minimum wage will increase to $15.50 per hour for all employers due to inflation. Now, this affects severely small businesses that have less than 25 employees and now are going from paying $14 an hour to $15.50. And also keep in mind, this also affects exempt employees because you also have to pass the salary test. I'll probably do another video about exempt employees, but do remember that at a minimum for them to be considered exempt, to pass the salary test, they must be earning $64,480 per year for them to pass the salary test. And mind you, I am not including the host of over a dozen cities and counties that have their much higher hourly rates, and I will definitely present a slide on that and maybe include that as a title, as a slide for this presentation, because you need to be aware of that as well. And the other one, quickly, this doesn't change much except that supplemental paid leave extension was supposed to expire September 30th, 2022. Now it's till the end of the year. It doesn't provide employees with new or additional sick leave or paid leave, but what it means is that now what's different is if you suspect, you can ask for a second test to be taken, and if they refuse, the employee refuses, the employer may decline to provide that additional leave. So, but you must still pay for that cost of that COVID-19 test. So that's what it is. That's all I have for today. I wanted to step in here quickly and cover this because we're in November and we have one more month left. And I really think it's really important. If you're a business owner, get in touch, talk to any employment attorney, talk to your HR departments, make sure your handbooks are updated. If you don't have a handbook, give me a call. I can definitely give you a referral for that because it's really, really important that you don't get yourself in trouble. Thanks all.